For today's webinar regarding the June 22nd Presidential Proclamation suspending the entry of aliens who present a risk to the US labor market following the coronavirus outbreak. That is the official name for this proclamation. And today we are happy and honored to be partnering with Vorys, Seymour, and Pease LLP to be discussing this proclamation. Our presenter today is Ms. Sachiyo Isoda Peterson, who is a partner at the Vorys Columbus office. She is also secretary of the JASCO Board of Directors. Sachiyo-san counsels and assists clients in the complex area of immigration, nationality, and employment sanctions law. Employment sanctions I-9 to be a little more specific. She focuses her practice on employment-based immigration and non-immigrant visas for global workforces. We are very happy to be able to present this information directly from Sachiyo-san because I'm sure she's probably in the midst of figuring out what this all means for American and Japanese companies alike here in Central Ohio. Today's presentation is going to be conducted in English. However, we will have Q&A available both during the presentation within the Q&A function of the webinar and afterwards as well if you would like to ask questions. English is fine. Nihongo demo daijoubu desu. So Sachiyo-san is bilingual, so as such we will be able to answer questions in both languages and receive questions in both languages. This webinar is being recorded today, so we just want to make a note of that. Based on the format of webinar, we're not going to see any of your faces, so don't worry about that. Also, we will be providing everyone with a copy of today's presentation in the days to come. So we have all of your information based on whenever you register, so we'll be sure to be in touch with you to provide a copy of the PowerPoint file afterwards. But for now, I'm going to step back and I'm going to turn everything over to our presenter today, Ms. Sachiyo Isoda Peterson.
Great, thank you so much, Ben. I'm very excited to be here. I'm excited to be sharing and hopefully providing some clarity to everybody during this ever-changing immigration landscape in this COVID-19 world that we're living in right now. There is new guidance, new information that is coming out what feels like on a daily basis. And so I will be providing you with the most up-to-date information that I have as of today, July 21st. As Ben mentioned, I know this presentation is being recorded, and so if anybody is viewing it at a later date, it's certainly possible that additional guidance will come out between now and then. But for now, we will dive right into what we know for today. So in terms of the agenda, I will first be covering just some basic immigration concepts about important documents that you might encounter in this process, as well as the difference between visa stamps and visa status, just so that we are all on the same page as we discuss the other agenda items. Following that, I will talk about the Presidential Proclamation, focusing on the most recently issued one on the June 22nd, and concentrating my focus today on how this impacts Japanese companies in particular, and how it will impact H1B and L1 visa beneficiaries as well. We'll then move on to talk about the current situation with the US Embassy and Consulate closures, and close by discussing how visa status can be extended from within the US when travel is complicated. Okay, so on the screen, you will see a number of different immigration documents that you might encounter. And depending on the visa category, you may not encounter all of these documents. So first, let's start with the approval notice, which you'll be able to see on the very right. For certain visa categories, you first have to obtain approval from the U.S. Citizenship and Immigration Services, or USCIS, before you can be in that visa category. For the visa categories that we're concentrated on today, this will most frequently apply to the H1B category, which is for specialty occupations or jobs that require a bachelor's degree in a specific area to perform. For our Japanese company clients, the H1B category is most frequently used for IT professionals, engineers, as well as other business professionals. You may also need to file a petition with USCIS and get prior approval for individual L1 visa petitions. So the L1 visa is for intra-company transfers. There's two subcategories, the L1A, which is for managerial employees, and the L1B, which is for individuals with specialized knowledge. For companies that are approved for the Blanket L program, the Blanket L approval will be issued on this approval notice. The Blanket L program is a special program for large multinational companies that are frequently transferring individuals from, let's say the Japanese parent company to the US subsidiary, or the Mexican affiliate to the US company. It's an easier way where the company gets pre-approved for the Blanket L, and then the individuals who are transferred on it. That process is a little bit easier because you can do it directly with the embassy rather than having to go through USCIS each time. So I've kind of already started talking about the Blanket L, so let's move on to the I129S, which you can see a sample on the top center of your screen. The I-129S is the form that is submitted to the U.S. Embassy or Consulate if the company is approved for a Blanket L program. And it's the form that's filed that qualifies the individual employee for either Blanket L1A or Blanket L1B status. Once the embassy approves that petition, they stamp the form where you can see that yellow box, and they will designate whether it's L1A or L1B, write in the validity dates, and this endorsed I-129S should be carried by all Blanket L beneficiaries each time they enter the US, just to ensure that they are given the correct expiration date each time that they enter. Now let's talk about the visa stamp, which you can see on the bottom left part of the slide. The visa stamp is a document that goes in your passport, and it is a travel document that allows an individual to enter the US in that visa status. It does not provide anybody with actual visa status, but it is a travel document that you show to Customs and Border Protection when you want to enter, and then assuming it's valid and assuming the CBP officer agrees that you should be given the status, then they will let you in. For Japanese nationals, the visa stamp is usually valid for 5 years. The validity of the visa stamp is determined by country reciprocity agreements that the US has with other countries. And for Japan, typically it's going to be good for 5 years, unless it's in the H1B category, in which case it's going to be limited to the validity of your approval notice. For both the H1B category and the L1 visa category, there's going to be something called the PED that is designated on your visa stamp. It's going to appear at the bottom right-hand corner of that visa stamp, and PED stands for petition expiration date. And so basically it's what it sounds like. It is the date that your petition approval expires. So for someone in blanket L1 status, that PED is going to be the same as your expiration date of your I129S. For individuals who are in regular L1 status or H1B status, it's going to be the same as your approval notice expiration. For E2 visa holders, they will not have a PED listed on their visa stamp. And then finally, at the top left-hand corner is the Form I-94. The one that you can see on your screen right there is the electronic version that is issued by CBP, Customs and Border Protection, when you enter the US. You can pull this record online each time you travel abroad and re-enter. It's certainly advisable for foreign nationals to pull their I-94 to make sure that the information was recorded correctly by CBP in terms of the visa category and the expiration date. This document is very important because it is the document that governs your authorized period of stay, or, that's kind of just the fancy way of saying it's the document that tells you how long you can live, and if you're in a work authorized status, how long you can work in the US. Most of the time, your I-94, if you're an L or H status, it should correspond with your PED. For individuals in E2 status, the I-94 is usually valid for 2 years from the date that you enter the US. But at times it can be shortened, and sometimes it's shortened by mistake. Sometimes it is shortened because your passport is expiring on an earlier date. But either way, even if you have a PED that's longer, if your I-94 is shorter, that's when your status expires. That's when your authorization of being able to live and work in the US expires. And so it is very important to closely monitor when someone's I-94 is expiring, because that is the document that controls that. So, just very quickly, let me walk through a scenario where these documents kind of come into play with each other. So a company sponsors an individual for an H1B petition that is filed with USCIS. Once that's approved, that approval notice is going to be issued. Let's say the individual is currently working for the company in F1 optional practical training. And so as long as they're here, they can continue to work on this approval notice. But then the next time they leave the US and want to come back, then they need a valid travel document. They need that visa stamp. And so they're going to need to go to the US Embassy or Consulate abroad, apply for that H1B visa stamp. And when they come in, they will show the CBP officer their visa stamp along with their approval notice. And assuming all is well, they will be allowed to enter. And then they will be issued an I-94 that can be pulled from the CBP website. So that's kind of how those documents interact with each other. And then just very quickly, one point of clarification in terms of the difference between visa and status. So as I already explained, a visa is a travel document that allows somebody to travel to the US. It only needs to be valid when you are entering the US. And again, the validity period of your visa stamp does not govern your authorized period of stay. That's what the I-94 does. And so this most frequently comes up in the e-visa context. For the e-visa, once you enter the US, like I said, the individual is usually given an I-94 that's valid for 2 years from the date of entry. So this would be the case even if your visa was expiring, the next day. So let's say someone enters the US today, July 21st. That means that they should be given an I-94 that's valid for 2 years until July 20th, 2022. Let's say that their e-visa expires on August 1st. The fact that the e-visa expires on August 1st does not impact their ability to continue to live and work in the US through their I-94 expiration date of July 20th, 2022. And so I think that was actually one of the questions that was asked. So I'm glad that I was able to cover that. Okay. All right, so now that we kind of have those basics down, let's dive into this presidential proclamation. On June 22nd, President Trump signed a presidential proclamation suspending the entry of certain non-immigrant visa holders through the end of 2020. And the visa categories that are affected include the H1B, the H2B, which is for temporary non-agricultural workers. A lot of the individuals who use the H2B are landscaping workers, as well as kind of the Disney World visas, individuals who are working in tourism, as well as in amusement parks. So, you know, a lot of the H2Bs are not going to be working for Japanese companies, as well as certain J1s. So the J1 visa is for cultural exchange, and there are a number of different subcategories within the J1, and so not all of them are impacted by the proclamation. The ones that are covered include the intern, trainee, teacher, camp counselor, au pair, which are the foreign nannies, summer work travel program. And so for, from the corporate perspective, you might have J1s who are interns or trainees. So there is certainly potential that those individuals are impacted. And then the L1, which I already explained, are the intracompany transfers, as well as dependents of these individuals, although there have been recent clarifications identifying exceptions for certain dependents, which I will discuss in the next slide. The June 22nd proclamation also extended an earlier proclamation that was issued in April, suspending the entry of certain immigrants seeking to enter as new permanent residents. So that's the green card side. Originally, that proclamation was valid for 60 days, but now it has also been extended through the rest of this year. Because the April proclamation doesn't have as much impact on Japanese companies, I'm not going to be covering the specifics of that. But we did issue a client alert that covers this topic at Vorys. And so if you want more information about that, feel free to go on our website and look for that. Or if somebody wants me to send it to them, I'm happy to do that as well. But for today, we're going to be concentrating mainly on that June 22nd proclamation. So this is kind of our pool of the text of the proclamation. So for individuals who meet all of the conditions that are identified in these bullet points, they are going to be subject to this proclamation. So if you are outside of the US on June 24th, 2020, and that's the date that the proclamation went into effect, individuals who do not have a non-immigrant visa in one of the affected categories that was valid on June 24th, individuals who do not have an official travel document other than a visa, such as an advanced parole document that was valid on that date or even issued afterwards. And then it also impacts, you know, individuals who are in one of those visa categories that I mentioned. So what does all of this mean in English? So the main impact for Japanese companies is going to be for new expats who have been waiting to apply for an L1 visa stamp at the US Embassy, either after they obtained USCIS approval or they're just directly making that application at the embassy through the blanket L1 program. Maybe one of your associates was waiting to either schedule an appointment to apply for a blanket L1, or they had an appointment scheduled and then the appointment was canceled because of the embassy closures that happened in March. With this presidential proclamation, even after the embassy reopens, these individuals will most likely not be able to enter the US through the end of this year. Another group of individuals who might be affected by the proclamation are those who departed the US maybe in February or March. They were scheduled to go to the embassy to renew their visa stamps. But then before they had the opportunity to do this, embassies closed, and now they're stuck outside the US and won't be able to return until 2021 because they're in one of these visa categories. Initially, another category of individuals we thought might be impacted by this proclamation were dependent family members. So a lot of times, I know with Japanese companies, they will have the associate come to the US earlier than the family. You know, the family is finishing up school, wrapping up their personal affairs, and the family will join the associate at a later date. But if they were unable to obtain an L2 visa before the embassies closed, then, you know, they were not able to, you know, get their L2 visas. And so they were unable to accompany their family members to the US. The Department of State, which oversees the US consulate and embassies, has clarified that if the principal applicant is in the US, then even if their dependents would be affected by this proclamation, they will still be able to apply for a visa to be reunited with their family. So that is a clarification that has been issued since issuing this proclamation. Okay, so who is not, who does this proclamation not apply to? Individuals who are in visa categories other than the H1B, the L1, J2, H2B are not impacted by this proclamation. So individuals who are in E2 status, TN, O1 extraordinary ability, these categories are not covered. So one potential workaround, if you have an employee who you've been waiting to bring over an L1 status and they're Japanese, might be to switch their visa category to the E2. Of course, we also have issues in terms of the embassies being closed. Okay, so Canadian nationals are also exempt from this presidential proclamation because Canadian nationals do not need visa stamps. They are visa exempt. And this proclamation only applies to the individuals who require visas. And then individuals who are currently working in the US in one of the visa statuses that are affected, they're in the US, and so they can continue to work in the US. They can continue to extend their status through USCIS without being impacted by this proclamation. Also, individuals who are in possession of a valid visa prior to June 24th can continue to leave the US and come back. And so, you know, if you have an L1 visa beneficiary whose visa is valid and their PED is valid through 2022, they can continue to leave the US, go visit family in Japan, business trips, and then re-enter without being impacted, even if they're in one of these categories. What is unclear is whether individuals who are physically present in the US on June 24th, but do not have a valid visa stamp, whether they will be able to renew their visa stamp while they are abroad and come back during this proclamation being in effect. And so just to go back to this slide, you know, the proclamation only covers individuals who are, who meet all of these qualifications. And the first one is that you were outside of the US on June 24th. So what happens if you're inside the country on June 24th, then technically it seems like the proclamation should not apply to you. And in fact, the Department of State has clarified on a number of different occasions that if you were in the US on June 24th, this proclamation does not apply to you. But until consulates provide more specific guidance in terms of how individuals can renew their visas by, maybe by showing that they were physically here on June 24th. It's hard to say whether the consulates will actually allow those types of individuals to renew. My guess is that they're not issuing that type of specific guidance just yet because the consulates are still closed. And so hopefully as the consulates start to reopen, there will be more detailed guidance in terms of how individuals can renew their L1 or their H1B visa if they were here on June 24th, and then be allowed to re-enter despite the fact that this proclamation is still in effect. And so we'll just need to keep monitoring that one to assess whether it is safe for somebody who doesn't have a valid visa to leave, and assume that they'll be able to come back. Okay. Sorry, there's a number of different questions, but I think I'm actually going to be addressing a lot of these questions as they come up. All right, so for other exceptions in terms of who the proclamation does not apply to, these are the exceptions that are outlined specifically in the Presidential Proclamation. So individuals who are a spouse or an unmarried child of a US citizen, individuals who are essential to the US food supply chain, and then individuals whose entry would be in the national interest. The national interest exception is kind of the broadest one. A lot of these are likely not going to apply to Japanese company employees. The ones that have been the most successful so far have been for individuals who are providing medical care and medical research to help combat COVID-19. But this fourth subcategory within the national interest, individuals who are necessary to facilitate the immediate and continued economic recovery of the United States. That's probably the one that's most interesting in terms of how Japanese companies might be able to utilize that exception to have people apply for visas despite this proclamation. So a couple of consular posts in Europe have released information regarding what they consider to fit under this economic recovery exception. Japan has not yet released specific information about what types of activities it considers to fall into this economic exception. But assuming that Japan adopts a similar standard to these posts, we anticipate that individuals who are going to be serving as technical experts and specialists to install, service, maintain, or receive training on specialized equipment may be able to apply for an exception. So even if these individuals are applying to for L1 or H1B visas, if they're going to be a technical expert working on specialized equipment, then they may be able to request that their visa interview be scheduled. So that potentially sounds like certain L1B visa individuals as well as certain H1Bs. And then also senior level managers and executives who provide strategic direction necessary for the success of the company. These individuals may also be able to fit into an exception. Okay, so let me look at these. Yes. Okay, just reviewing some questions. So I think one of the questions was about if you are currently an L1 visa holder living in the US and you go on a business trip to either Canada or Japan, can they come back into the US? And so if you have a valid visa stamp, so your visa stamp is still valid, then even with this presidential proclamation, you still should be able to return to the US. Okay, all right, so let's talk about embassy and consulate closures because some of the questions refer to this topic. So in March, the Department of State suspended routine visa services worldwide due to COVID-19. And starting on July 15th, so just last week, certain consular posts are starting a phased reopening. And basically what that means is the consulate locations are monitoring local conditions of COVID-19, assuming their levels are not too high, then they are moving towards reopening that location. But then also within the various locations, they're also assessing which services they will start offering again. And so not only is it a phased reopening in terms of locations, but it's also a phased reopening in terms of the services they're going to offer. A lot of posts are saying that they're going to be prioritizing services that are provided to US citizens first. And then they will start offering, expanding more services. Some posts are also saying that they'll prioritize certain visa categories first, but not others. So there's been discussion about certain posts issuing and prioritizing international student visas because they are subject to a very specific start date with the school. And so it's all different based on post. Some posts are starting to provide updates on their website in terms of when they're going to reopen, what types of services they're going to start offering first. But not all posts are offering that information, including Japan. Japan has not posted any sort of information about when they're going to be reopening just yet. From some insider information we were able to get through some connections we have at Vorys, it is our understanding that the US consulate in Osaka, Kobe is likely to reopen before the Tokyo, the US embassy in Tokyo, just based on the local COVID situation in Osaka versus Tokyo. But again, we don't have any specific dates in terms of when the consulates will be reopening. So despite the fact that routine visa appointments have been suspended, there are certain situations where you can still continue to submit visa applications and have them processed without an interview. So for visas for children 0 to 13 and the elderly 80 plus, they don't require an interview, and so you can renew their visas by mail. And then for certain individuals who meet criteria that you can see on the screen, mail-in visa renewal may also be an option. So I've highlighted the main ones being that you have to be physically present in Japan. So even though this is a mail-in renewal process, you cannot mail your passport to Japan, to the US Embassy in Japan and have it renewed. You actually have to be physically in Japan to take advantage of this process. Again, this is just for renewal. So the mail-in visa renewal does not apply for first-time applications. It only applies for individuals who have never had an ESTA application denied. never been arrested, you have a visa that is still valid or expired within the last 12 months, you're applying at the same location. There's some other requirements but these are the main ones that you have to meet to use this mail-in renewal process. Probably importantly for Japanese companies in particular is that blanket L1 visas cannot be renewed by mail. But for e-visas, they can be renewed by mail. So that is certainly one option to renew e-visas even during the embassy closure. Just as a note, using the mail-in process does not guarantee visa issuance. In some cases, if the embassy or consulate has questions about your application, they can ask you to come in for an interview. And if this happens during the embassy closure, then, potentially you could be stuck in Japan until the embassy reopens. They're able to take your interview, and then they can issue you your visa, and then you can finally return to the US. So that's certainly a big risk that's associated with the mail-in visa renewals when the embassy is closed. And also the average processing time for this mail-in visa renewal process is very long. In Tokyo, it's 10 business days, and in Osaka, it's 2 to 3 weeks. Okay, so there's a question asking about, so if the Osaka consulate or another consulate opened earlier, is it possible to transfer the case that was originally submitted to Tokyo to Osaka? That's a great question. I would think that you would be able to, well, because let me think about that. I mean, I think that you would be able to transfer a case. I mean, it probably depends on what process, what part of the process you're at. I mean, if you've already submitted the application and it's pending at Tokyo, you probably wouldn't be able to submit it to Osaka. But for most people, I assume where you're going to be in the process is you haven't actually submitted the application. You've just done the DS-160 and you've identified Tokyo as your location. In that situation, you can use that DS-160 even if it's designated for Tokyo, and then schedule an appointment at Osaka and not have to worry about redoing your DS-160. In terms of like a transfer where an application is pending, then you might need to be able to show some sort of connection to the Osaka area that will allow you to transfer it to Osaka. But that's a great question. Okay, there's another question, but I will actually address that one when we get to that part of our presentation. Okay, so there are also situations where you might be able to request an emergency visa appointment even though the embassy and consulate is closed. So these limited number of emergency visa appointments are available for urgent business travel. And urgent business travel is defined as, if a US company will suffer significant loss of opportunity, or if the individual is going to be coming to the US for a training program in the US of 3 months or less. Even with this emergency visa appointment process for first-time visa applications, this will most likely be used for e-visa applicants. It's unclear whether this emergency visa appointment process is available for L-visa renewals who are physically present in the US on June 24th. So how do you schedule this emergency visa appointment? You just go through the normal visa appointment scheduling process, schedule an appointment with the earliest available date, and then you would submit a request through your US Travel Docs account where you schedule that appointment, or you can send US Travel Docs an email requesting an emergency visa appointment. You would provide a detailed explanation of the situation, identify when you intend to travel, and then include supporting documents. So for e-visa applicants, you must submit a copy of the DS-156E Part 3, include an invitation letter from the US company describing that urgent business travel need. And if it's for a training program, then you would also submit evidence of that training program. And then the embassy will then notify you whether they are going to accept or deny your emergency visa appointment request. A question that we've gotten frequently is, if we submit this emergency visa appointment and the emergency appointment request is denied, will that impact my application? No, we don't anticipate it to impact your application, because this is just, a request for the emergency visa appointment. It's not actually your submitting your visa application. However, the embassy has cautioned that if your emergency appointment request is granted, but they find out that you actually misrepresented or lied about your urgent travel, then those facts could negatively affect the outcome of your application. So, as for any circumstance, we never recommend misrepresenting in any way. Okay, so finally, when it's not possible to extend your visa status by traveling, so typically an individual an e-visa status might be accustomed to just traveling to extend their I-94, but it's difficult to do so with all of the travel restrictions in place, or for a blanket L1, maybe you typically extend visa status through the embassy or consulate because you know that USCIS extensions can be more difficult for the L1 visa category. For those individuals, when they can't go to the embassy right now because it's closed, there is an option to extend visa status, and that is through filing a petition with USCIS. The earliest you can apply for a USCIS extension is 6 months before the I-94 expiration. And also a timely filed extension in the same visa category will provide you with a 240-day extension of work authorization. So that means, if your I-94 is expiring on August 1st, we file an extension today, then that individual can continue to work and continue to live in the US. Well, they can continue to work for that 240-day period from the expiration of the I-94. And so, just because the I-94 expires, it doesn't mean that they'll be out of status or out of work authorization. They can continue to work based on that timely filing. There's always questions surrounding the driver's license renewal process when somebody files an extension with USCIS, because typically, these individuals are able to just take their I-94, renew their driver's license based on that. And so what happens when you have an expired I-94, your driver's license expires on that same day? How can these individuals renew their driver's license? Well, you can do that in Ohio through presenting a copy of your receipt notice. And the receipt notice is typically issued, 2 to 3 weeks, sometimes earlier, after a petition is filed with USCIS. So you can take that receipt notice to the BMV and renew your driver's license based on that document. For individuals in different states, that rule can differ. It just differs from state to state. And so you'd have to look into whether that's a possibility. And just kind of as a side note, with the ongoing COVID-19 state emergency, Governor DeWine in Ohio has actually signed a law that automatically extends driver's licenses for the duration of the state emergency or until December 1st, 2020, whichever comes earlier. And so, you know, some individuals may actually have a automatically renewed driver's license based on Governor DeWine's actions, even without worrying about having to use their receipt notice to renew. So that takes care of the meat of our presentation. Let's see, there are a number of questions in the chat too. So yes, do you know if there has anything in this process has changed in terms of the I-129 being submitted by the employer? So in terms of the USCIS filings, you know, in terms of like the substance of the petitions that is filed, there has not been changes based on COVID. Procedurally, there's been some changes, like right now, USCIS is allowing us to file petitions with electronic or with scanned wet signatures instead of needing to submit the forms with original signed documents. So there are some, you know, procedural things that are going on that have changed, but in terms of, you know, the I-129 itself, there have not been any changes. There's another question about the 240 days. So for the 240-day extension, this is a calendar day, 240 calendar days, not business days. There's a question about if USCIS employees will be furloughed in August, do you think it will affect the visa application progress? I do. It's unfortunate, but USCIS has announced potentially that there may be furloughs happening in August if they're unable to get more money in their budget. And if that does happen, it sounds like there will be a significant number of employees at USCIS who might be furloughed and impacted by this. And so I would have to think that that will result in slower processing times. Surprisingly, up until now, we have not really noticed that much of a slowdown in terms of the processing times since, you know, March. But if there were to be a furlough, I would anticipate that there would be a slowdown. Okay. So if there's a personal emergency, such as bereavement happens in Japan, and the e-visa has been expired, but I-94 has not, can this individual come back to the US? So in this situation, since they are in Japan and need to return to the US, they would need to have a valid e-visa to show to CBP to be able to re-enter. And so even if they have a valid I-94, they need to have a valid e-visa to be able to return. And so, you know, hopefully if there's someone who already has an e-visa, they can take advantage of that mail-in renewal process. You know, since they're already in Japan, I don't think it would hurt to try the mail-in renewal process. It's mainly more risky for individuals who are here trying to travel back to Japan to see if they can get it renewed in that way. But if they're already there, then they might as well try. Has there been any changes to the strictness of customs upon entry for those whom are eligible to enter the US? We have not, obviously there are a number of different travel bans that are happening right now, which we didn't really go into because it would uncover kind of a large host of other topics. But in terms of just general strictness of individuals who are able to enter the US, we have not seen too much of a difference in terms of how people are being treated at the border for reentry. Does the proclamation mention the possibility of decreasing the number of H1B visas issued annually? If so, would the renewal be influenced? So the proclamation does not address the possibility of decreasing the number of H1Bs issued annually. Because the proclamation only addresses H1B visa stamps, in terms of extensions, like I said, you can continue to file extensions through USCIS without being impacted. Okay, if a blanket L1 visa holder wants to go back to Japan to see family, is there any risk of them not being permitted to re-enter the US when they return due to the new proclamation? So again, assuming they have a valid L1 visa stamp and their PED is still valid, they should be able to leave the US, re-enter, even with the proclamation. Okay, there's another question. Do you know if we can expect to file a new H1B petition on April 1st, 2021 for the new H1B fiscal year? Do you expect any impact on the new fiscal year quota in 2021? As of right now, I don't anticipate an impact on the quota. Of course, that can change because I do know that as a part of the latest proclamation, there was a directive included in there to assess, how can the government protect U.S. workers in this COVID-19 economy for individuals who are currently inside the US. And so certainly, I guess from that directive, there could be a change that comes about. But in terms of changes that come about that will impact individuals who are in the US, it will need to go through, a comment period, and it won't be able to be done just through executive order. And so we'll know about these changes before they come about. In terms of the timing of being able to file a new H1B, I would anticipate to be the same as this year, where there was that employer registration process that happened. Okay, do you expect any impact or changes on OPT? Again, that's something that could happen in terms of the changes that are being assessed from within the US. There were also, certain policy changes that happened recently that impact the international students. Back in March, there was a relaxation of the number of online classes international students can take, because typically there's a pretty restricted number of credits that you can take online. But with COVID, they relaxed that requirement. But then earlier this month, ICE came out and basically took away those relaxed measures. But then, as many of you likely know, there were lawsuits by large universities that then resulted in ICE rescinding that earlier July policy. And so, there's certainly possibility that OPT could be impacted, but we don't know exactly how that might happen yet. Okay, that one. In terms of the mail-in renewal process, there are other consulates that offer that mail-in renewal process. Some of them refer to it as the Dropbox process, and whether consulates offer that option right now, even with the embassy closures and the consulate closures, will just depend country by country. And so you'll have to check the website of that specific consulate to determine whether the mail-in renewal option is available. Okay. All right. Gosh, it's already 10:58, so I guess we'll just keep taking these questions by chat. Unless, Ben, do you think that we should take one question?
I mean, sure, if everyone has any questions that they prefer to ask in voice rather than Q&A, please raise your hand using the function in the channel, and we can attempt to answer questions. We have a few more still in the mix though, so I'll leave it up to the individuals what they would like to do.
Great. So there is another question here. So if you are an L1 visa holder and in November your visa and your I-94 are expiring, does that mean that you can continue to reside in the US for 240 days? And so in this situation, yes, assuming that you file an extension before the I-94 expires, you can continue to live and work in the US for that 240 days, even after the I-94 expires. Okay, I think that answers pretty much all of our questions, and we are just out of time as well. So to the extent that you have any follow-up questions that I didn't answer or that you would like to ask privately, my contact information is listed there. Feel free to reach out, and hopefully you gained some clarity today, and we'll keep monitoring the situation and see what happens. So thank you for joining us today. I really appreciate JASCO hosting me and giving me the opportunity to do this. And thanks, Ben.
Thank you so much, Sachiyo-san, for these insights and these perspectives and what is obviously a constantly evolving situation. So who knows what the next weeks or days will even bring to us. As was mentioned at the beginning of today's webinar, we have recorded this, and we will be determining the best way to get everyone a copy of this recording of the presentation. We will be also working to get everyone a copy of the presentation file itself that Sachiyo-san has created. So we have all of your emails from whenever you registered, so please look for more communication from us in the days to come. As for now, I guess we'll just wrap everything up here. Thank you so much to everyone to attending. Once again, thank you so much to Sachiyo-san for participating, providing your insights, and to Vorys, Seymour, and Pease LLP for serving as a co-host of today's event. So yes, thank you very much, everybody, and have a lovely day.